If someone you loved passed away and left a will that doesn't feel fair, you might be wondering something most people are too afraid to ask. Can someone who isn't a blood relative actually contest a will? A lot of people assume the answer is automatically no, that only children, spouses, or close family members have any rights. But here's what surprises most people. That assumption's not always correct. And misunderstanding this can be the difference between having a valid claim in contesting a will or missing your chance entirely. So, before you decide that you have no options, you need to understand that every legal matter is unique and the law depends on specific facts in your situation. When someone dies and leaves a will, emotions are already high. People often feel confused, hurt, or even shocked by what the will says. One of the most common questions we hear is, do I even have the right to do anything about this? Some people immediately assume that they're excluded from having any claims because they aren't blood family. Others assume that being named or not named in a will is the final word, no matter what. But that's where things can get more complicated than most people expect. In probate law, the question isn't just who you're related to, it's often about your legal interest in the estate. That distinction is where many people misunderstand their rights entirely. This is a layer most people don't think about. It has to do with what courts actually look at when deciding whether someone can challenge a will. So, before we can answer who can contest a will, it helps to understand what contesting a will actually means. Contesting a will means legally challenging whether or not a will is valid. Contesting a will doesn't automatically mean the court will throw it out. It just means that someone is asking the court to take a closer look. Courts usually focus on a few key issues when a will is contested. They look at if the person who made the will was mentally capable. They ask if the will was created under pressure or influence, and then they check to see if the document is valid and properly executed. To raise these concerns in the court, you do not need to be a close blood relative, but you do generally need what's called standing. Standing just means you have a legally recognized interest in the outcome of the estate. And that concept is where most of the confusion starts. For example, let's say someone was in a long-term relationship with the person who passed away, but they were never married. Or maybe a stepchild who was never legally adopted, or even someone who was financially dependent on the deceased. In some situations, those individuals may still have a legal basis to challenge or to be involved in probate proceedings, but it depends heavily on the circumstances. Many people assume that if they're not named in a will, they automatically have no rights at all. But in some cases, prior promises, financial dependence, or legal relationship may still matter. This is exactly why these cases are rarely simple, because what looks straightforward on the surface often isn't once the legal rules are applied. So, can a non-blood relative actually contest a will? The answer depends less on family labels and more on legal standing, evidence, and the circumstances surrounding the will itself. This is where things get more nuanced than most people expect, because the law is not only looking at who you are, it's also looking at how you're affected by the outcome of the estate. So let's break this down clearly. Yes, in some cases, a non-blood relative can contest a will, but it's not automatic. It's not based solely on emotional closeness or informal relationships. In general, a person may be able to contest a will if they can show they have a legally recognized interest in the estate or were directly impacted by the validity of the will. That could include situations where someone expected to inherit under a prior will, had a legal or financial relationship with the deceased, or can demonstrate a legitimate basis under probate law. However, courts are careful with these cases. They do not allow just anyone to challenge a will simply because they disagree with it or because they feel left out. And this is where every situation becomes very fact specific. Every case is different. The facts are very important. Laws can vary state to state. And that's why an attorney who understands the details of your specific situation is essential before making any decisions about contesting a will. What applies in one situation may not apply in another, even if the relationship seems similar on the surface. So if you're facing a situation like this, remember that your case is different. Your specific facts matter. This video is for educational purposes only. It's not legal advice, but if you'd like some legal advice, if you want to understand how the law may apply in your situation, the attorneys at Woodbury and Ibarra offer free consultations if you mention this video. They are experienced, have a lot of specific training in this area, and can help you know how to proceed and what next steps to take. The link to the website is below, and a phone number as well. Again, mention this video and you'll get a free consultation with one of them.